Okay, welcome back, Chalk and Gavel listeners. It's episode 26 today. Just a few quick points before we get started. We would love it if you would rate and review Chalk and Gavel on your favorite podcast platform. That does a lot to help us spread the word.
We would also love it if you could support us on Patreon if you like what you hear. And you want us to continue delivering the education law content that you've come to expect. Just $2 a month will help us continue building and producing and growing the show.
Yeah. And lastly, as the school year begins, this is just a reminder that we have put together a teaching guide for those of you education law professors or anybody else who's just interested in accessing the content that we've produced on this show by topic. There's guiding questions. There's lots of stuff that you can use in that teaching guide that will help you promote legal literacy. So you can find that teaching guide on chalkandgavel.com. And now let's get to today's show.
When can a school discipline a teacher for their social media use? What happens when a teacher's problematic tweets go viral? Was 2016 seriously 8 years ago?
Oh, 8 years ago.
I mean,
already?
It has to be, right? Because we're 2 presidential elections later.
It feels like it was yesterday, but it also feels like it was forever ago.
It was a lifetime ago, and yet it happened yesterday. Yeah.
Feels like it's happening again, doesn't it?
It does feel a little Groundhog Day, doesn't it?
So imagine waking up to an email about 8 years ago detailing a teacher's history of retweeting and commenting on some rather controversial posts. Well, that's exactly what happened to a West Virginia school board's communication director when one of the district's high school teachers, when their Twitter activity sparked a firestorm in the community. In today's episode, we're diving into the case of Durstein versus Alexander, a legal battle that challenges the boundaries of free speech for educators and explores what happens when personal beliefs collide with professional responsibilities.
Welcome to Chalk and Gavel, where we explore how the law shapes education one case at a time. I'm Chris Thomas. I've been a high school English teacher and a school attorney.
And I'm Jamie Cudlitz. I've been a middle school math teacher and principal. And now we're both professors of educational leadership, working to empower folks to better understand and navigate the laws that profoundly impact our schools.
This is the show that tells the fascinating stories connecting the courtroom to the classroom.
Chalk and Gavel is for educational purposes only. While Chris and Jamie always try to provide accurate information, the law is like what I'm willing to eat. It's always changing. This podcast is not legal advice and does not create an attorney-client relationship, but they promised me it would be a lot of fun. For you. Can I get my candy now?
All right, Jamie, I think you've got our bell ringer for today.
Yeah, we haven't really talked about this very much on the show. We did an episode that had to do with searching a student's cell phone, but we haven't talked about these cell phone bans at all. And I'm sure that if you're keeping up with any news about what's happening in the world of schools these days, cell phone bans seem to be popping up rather frequently here and there. And some states are, exercising these sort of complete bans. I think South Carolina maybe and Florida are pretty sort of universal bans, while other states are making their usage, okay during non-teaching times, or, like there's different levels of cell phone bans.
Sure.
But I listened to this Morning Edition episode by Rachel Cohen on NPR the other day, and she was talking to some folks at a school out in Colorado, at a high school out in Colorado that has imposed this complete cell phone ban. And apparently what they do there at this high school is they make the kids put their phones into these bags that magnetically seal. And the kids are supposed to put their phones in the bag at the beginning of the day, and then they have to take that bag to a specific place in the school at the end of the day that has that unlocking mechanism to get those bags unlocked, right? So they can get
So it's like
phone.
the magnetic cases that used to come on CDs where you couldn't open the CD case until you got to the cash register.
Yeah, and they swiped it. Exactly. Now, CDs, kids, CDs were these little... I'm just kidding. Okay.
Oh, wow. Okay. We're both showing our age today. That's good.
Yeah. And so like the episode talks about how one of the SROs, I guess it is, who's collecting the cell phones at the beginning of the day, they have to inspect everything that the kids are putting in there because they try to, put burner phones in there or empty phone cases or packs of gum or whatever to try to get around the rule.
Right.
So they have to get pretty strict with that rule. Kids obviously don't like it too much.
Right. Well, that's what I was going to say is I like that they can keep their cell phone, their bagged cell phone with them during the day because that alleviates some of the concerns with cell phone bans where if the school has to collect all these cell phones, now that creates a whole separate issue where now the school is in possession of these cell phones and that can lead to problematic consequences.
Yeah.
But if it is, they have them with them, that kind of alleviates some of that. Obviously, you have to get the bags themselves. But the thing about students and cell phones, that cell phone is, if not the most important, one of the most important things to that kiddo.
Right.
So obviously they're going to find a way to get around this policy. You said they're very creative, especially with new technology. We're 3 steps behind them all the time.
Right. And they're not necessarily trying to get, I don't want to paint the picture that they're trying to get around these policies for sinister reasons so that they can use the phone in ways that goes against school policy or whatever. There's a lot.
Right.
I mean, while some kids are obviously going to do that.
It's more just having it, right?
Yeah. It's a comfort for them. I mean, there was a student who was interviewed on that show basically said, this makes me uncomfortable. What if there's an emergency and I have no way of contacting my parents and everything? And that's interesting, right?
Yeah. You think about all the stories about school shootings and the messages and communications that come out of that when those students have their cell phones. But it's a safety thing too. But when I don't have my cell phone, sometimes it feels like I'm missing a limb because it's I'll reach into my pocket and it's oh wait, no, it's not there.
No. And I think that, I think that's it. And I think, it's healthy for us to break free from these things every now and then. But
which I think goes to the educational mission, right? And the reason for these bans is to break those habits, to get people to live in the moment, to keep distractions at bay.
Right. And so that the students can focus on their learning and blah, blah, blah. Mm-hmm. And I think that, from a legal perspective, I wasn't able to find too many cases that dealt with sort of the constitutionality of cell phone bans. There was a case from New York back in 2008, I believe. It's Price versus New York.
Oh, wow.
Dealt with that question. And basically the court's answer was cell phone bans are not unconstitutional because if they're related to a legitimate pedagogical concern, a cell phone ban is fine as long as the kids have access to those phones before and after school, for example.
Okay.
So,
yeah,
like you said, the school isn't necessarily, at least the example from that Colorado school, the school isn't taking the phones. The school is letting you hold on to them, but you just can't access them during the school day.
Right.
So this is an interesting thing because of how reliant we all are on these cell phones and how much of a part of our lives these phones have become. To unplug for the day is obviously going to be difficult.
For sure.
Right?
But this makes me think of the social media litigation that we talked about earlier in another bell ringer, where these school districts are suing these social media companies because of kind of their efforts to make their products more desirable for kids, to get kids hooked on their products. And schools have to deal with kind of the fallout of that. So this seems to be kind of a natural outgrowth of okay, well, look, we've seen the negative consequences of cell phones. Mm-hmm. So what do we do now? Maybe we need to be a little bit more assertive about keeping those out and creating a place free of cell phone usage to let kids not be beholden to those sorts of activities or the social media and, unplug, right?
Exactly. Exactly.
Yeah. Interesting.
Anyway, so these, I think we're going to see more and more of these bans, that at least some degree of banning. We know a lot of schools already have that, but I think what we're starting to see a lot more of now are these pretty broad, all-encompassing bans.
Right. It's not a don't use it at school. It's a don't have it at school.
Yeah.
Right. That's
exactly.
a huge difference.
Yeah. So there's your bell ringer for today. All right. So let's get into Derstein versus Alexander. This is a case. It took place. This is a very similar case to one of the other cases that we've discussed in an earlier episode, the TS versus Talladega case that had to do with some political activity at school around the 2016 election. And this case, the Derstein case, is taking place pretty much right around the same time, okay, and dealing with very similar kinds of political issues and statements, right?
That's right. Yeah, because the Talladega case involved a student who, after the election, wrote Trump 2016 on the blackboard. There was some policies around that he may have violated. Now, this one is about teacher speech.
Right.
In that same context.
Right.
Okay.
Exactly.
Speaking of Groundhog's Day, not only have we covered similar topics in other episodes, but we're in the middle of another presidential election cycle.
Exactly. So, this is potentially pretty relevant to what we're going to be seeing this fall.
Yeah, over the next, 85 days?
Yeah, hopefully not, but...
hopefully not, as we'll talk about.
Yeah. So, okay, so let's talk about what happened here. So we've got Mary Derstein, who worked as a teacher in, is it Cabell?
Whatever it is, I need more of it.
Oh, it's not cowbell.
No, it's not. It's Cabell. Yeah.
I'm going to say Cabell County.
I like Cabell County.
Yeah. That was funny. So Mary worked as a teacher in this county for 18 years from 1999 to 2017. And in the 2016-2017 school year, she got into a little bit of trouble. See, because in 2016-2017, as a world studies teacher to freshmen at Huntington High School, she was a little active on Twitter that year. Okay. Now, as a world studies teacher, they do cover a lot of things in those classes that have to do with world cultures, right? And, the different features of world cultures and religion and political, historic features, the major contributions from different cultures. And according to the court record, the classes that Mary taught had a pretty diverse student body. And that's about all that we know about the class that she taught and the students that she taught, right? So what happened in this is an interesting story. So Mary's pretty active on Twitter, right? On January 8th of 2017, a former student from that high school who was a journalism major at one of the universities somehow came across all of these tweets that Mary had either reposted and commented on, or her own tweets or whatever. So this former student came across some of those tweets. And you want to hear a little bit about these tweets?
Yeah. So before we do that, I love that it's a former student who is now a journalism major. That just makes me so happy, because talk about some hard-hitting local investigatory journalism, right? I love stories of students kind of making their voices heard. And I wrote a book about student protests. So this is right up my alley.
Well, I just, I wonder how this former student decided to investigate. Did this student just stumble upon a tweet one day going, hey, I know that teacher, or I know that high school, that's my former high school, or whatever, and then went down the rabbit hole? Or did this teacher have a reputation at the school that caused this journalism student to say, you know what, I'm going to do some digging on this particular person and see what I find?
Right. Yeah.
Right?
I don't know. And I don't know if the record has that, but with anything what it was like being a teacher and a school administrator, your students, you're a minor celebrity to them, right? So they'll dig, they'll find you on social media.
Yeah.
Apparently, her account was very easy to find. It was attached to her real name. So
she wasn't hiding anything.
Right. Yeah. This was not a pseudonym that was purely, hidden. And it was a public account too.
So let's talk a little bit about these tweets to give our listeners a very clear understanding of what was at the heart of this case.
Sure.
Essentially. So here, we're just going to run through a handful of tweets here. So one of her tweets was just a retweet of conservative commentator Ann Coulter's tweet that contained a photograph of 2 men and 5 women. Some of those folks were wearing hijabs, and the caption read, "Deport them." Okay. One of the men in the photo was somebody who had opened fire on 2 military installations in Tennessee. Another post that she made on Twitter was a retweet of a post that contained 2 photos. One of the photos had President Obama laying a wreath in Japan, and that photo had the caption, "Obama in Japan, Memorial Weekend apologizing." The other image was of the USS Arizona Memorial at Pearl Harbor with the caption, "This is where you belong, you Muslim expletive."
Wow.
And she retweeted that and had a comment when she retweeted it. And her comment was exactly with a bunch of exclamation points.
Okay. So she didn't use the derogatory, but she said exactly like kind of saying, hey, you got it right.
Yes, she was pretty much agreeing with that
Got it.
sentiment from that tweet.
Oh man, 2016, like I forgot like all of the like
there was a lot of vitriol.
Anti-Obama stuff,
Yeah,
right?
A lot of vitriol. So there was another tweet that had a picture of a man with his arms around a woman who was in full Muslim garb, a burqa and everything. And the text in that photo said, "Islamist advantage. When you divorce your wife and remarry, you can still keep the same photo on your desk." And her comment on that tweet was, "Too funny not to tweet."
Okay. So I'm noticing a pattern.
Yes, there seems to be a pattern here.
Yeah. Maybe some xenophobia.
Right.
Yeah.
And so those were, 2015, 2016. There was another tweet in 2017, right at the beginning of 2017, when all of this stuff was really about to take off. There was another tweet where Mary responded to some tweet that contained mugshots of Black teenagers. And the caption said, "Can you imagine how many riots we would have around the country if the terrorists were white?" And she commented, "This could have been Obama's children."
Okay. So we're adding some
Some different races to the racism.
Yeah.
She also made another comment on that same photo that said, "Nothing but irrelevant thugs, throw them." I'm assuming she meant to say in jail. It says throw them jail, save future victims. So yeah. So there's stuff.
Right. And that last one was like January 5th. So that's like right before. I wonder if that's the one that
might have shown up on the feed of this journalist
to cause them to go a little bit deeper.
Yeah. Yeah. So that journalism student found all those tweets and started retweeting them. And then that got some more social media attention, and others began to dig and retweet Durstein's old tweets.
Right. Which, if there's something the internet is very good at, it is never forgetting.
Yeah.
And it is finding something that you said on the internet.
Yeah. And I mean, like, there's a lot of other ones that they dug up. One stated, "Who cares if we offend Muslims? At least they keep their heads on tact." That wasn't.
You can tell she wasn't an English teacher.
Yeah, she did not spell that right. I don't know what she meant to say there. She said, "They're the enemy." There was another comment that she made that said, "Awesome. Do you care if I share with my alt-right friends?" Smiley face. And she was commenting on a picture of Hitler's face in the shape of a swastika superimposed on Donald Trump's face.
Whoa.
Yeah. But wait, there's more.
Oh, gosh.
There was another comment on a post that said something like, "Only until January 20th. And that is true. No more political correctness after the 20th of January. Keep in mind, this is 2016. So
inauguration.
Yeah.
Day.
So they're basically, she was basically saying, once Donald Trump is in office, there's no more political correctness. Finally, she says, finally liberated.
Not like she was abiding by that before 2017.
Yeah. So anyway, so somebody, basically decided to tweet all of these things
right
at the Twitter accounts for the school district. All right. And the high school.
Mm-hmm.
So this gains steam on social media, people digging and finding all these tweets. And then some people were just like, okay, now I'm going to send all this stuff to the district and let them deal with it.
Right. And that tends to be what kind of happens in these sorts of situations where people are saying stuff like this online. Like, people will notify their employer, and that's usually when kind of, the rubber hits the road and a lot of consequences start to come about.
Yeah. So, again, we mentioned that the journalism student started finding and retweeting all of these things on January 8th. Well, on January 9th, this hit the district, all right, at about 3:30 in the morning. The district's director of communication received a bunch of notifications sharing those tweets, okay, with the district.
Not the email I want to wake up to.
No. And around the exact same time, some other Twitter user sent all this stuff to the local news.
Mm-hmm.
All right. Well, that's fun. So that's what everybody woke up to on the night.
Yeah. And the local news copied the communications director in that email too. Just like, hey, FYI, we got this stuff. We're going to run some stories on it.
Mm-hmm. So the communications director for the district got in touch with the assistant superintendent, whose name was Todd Alexander, and Alexander got in touch with the high school principal, Jody Cunningham, who's already getting phone calls about the tweets asking the school to investigate.
Right. Yeah,
Okay.
This thing picked up steam very quickly.
Very quickly. So the school officials decide to meet with Durstein. They call her down to the principal's office, and during the meeting, they talk about these tweets. And at some point, so like obviously they're staying on topic.
Right. And very proactive, right? Like, very first thing in the morning, like, hey, we've heard some stuff. Let's go straight to the source.
Yeah. So they did. At some point, Durstein logs into her Twitter account on the principal's computer and deactivated the entire account. Now, she claims that she was told to do so by the assistant superintendent.
Okay.
Right? Now, the principal and the assistant superintendent's version is that it was more of a suggestion advising her of the best course of action. However, everybody agrees that the assistant superintendent never told her that she could or could not reactivate the account.
Okay. So like the from the principal and the assistant superintendent, they're trying to do damage control at this point, right? Like, they want these offending tweets off the internet.
Right. Now, it's, whether they told her to deactivate the account or they suggested that she deactivate the account was deactivated, but everybody agrees nobody said anything about whether or not she could reactivate it.
Okay. Yeah, because I think like, Jamie, you've probably heard this advice or were given this advice when you got into teaching. Like, a lot of the advice is, hey, don't have social media. Like, stay far away from social media because you want to avoid stuff like this. Yeah. And I always take that with a grain of salt because of what we'll talk about here in a second. Like, just because you're a public school teacher doesn't mean you give up your First Amendment rights to free speech.
Exactly.
So like, this idea of a principal ordering someone to delete their social media, like that obviously, putting aside the content of the tweets right now, like, I worry about that if that's what actually happened.
Well, that's where a lot of the discrepancy here in this case seems to lie in, Durstein's account of how forceful the school was, So, the other thing was Durstein also said that the assistant superintendent told her not to speak to the media. Durstein said that was an order. The school says that it was a suggestion. So very similarly, there's a discrepancy there as to, whether or not these things were orders, directives, or suggestions. And if they were suggestions, how strong were they? Like, it's hard to say when you're not there and you can't hear the tone and all of that stuff. I mean, I think it's perfectly reasonable for somebody to assume, depending on the context and the tone and all of that stuff, that a suggestion would sound like an order.
Right. Yeah. Given the context and like you got called down to the principal's office, right? Like, that has a certain weight to it or certain context.
Yeah. And so at the end of that meeting, Durstein was told to go home. She would be on administrative leave.
Okay.
Yeah. Okay.
So within like hours of hearing about this, they've already talked to her. They put her on administrative leave. They start an investigation.
Yeah.
Like, you got to applaud the school district here for being proactive and like not sitting on their hands with something like this.
Yes. Yeah. Absolutely. So obviously a few days go by and this gets a lot of attention. Okay?
I can imagine.
So parents, other members of the community, they're contacting the school. The same day that Durstein met with the principal and the assistant superintendent, The local news was running stories on the issue. The first story that they ran, the district's director of communication gave a statement that the district had become aware of the tweets that morning and was pursuing an investigation. The second story, at 10 o'clock at night that night, the director of communication gave more commentary and discussed the board's expectation that teachers provide safe and secure classrooms, and added that she was asked to delete her account, which she did.
Ooh, okay.
So
I have two thoughts.
yeah, that's
Thought
it.
number one. Well, that's a lot for me. Thought number one, I think you made me lose both of my thoughts. No, here they are. Thought number one, the district is talking to the media, but according to Durstein, the district told her not to talk to the media. I don't like that. That feels
Very
unfair, unbalanced, right? Like, because deleting the account, that's speech that happened in the past. Forbidding her to talk to the media like that, like she doesn't have a chance to defend herself, assuming that's, if that's what she wanted to do, or like to explain the context, or just to give her side of the story.
And that's probably, I agree, like that's probably why in so many of these kinds of cases, and I don't mean like, social media cases, I just mean in cases where there is some sort of ongoing investigation, especially when the media is involved, the school and the school district will often say, we're not going to comment on personnel matters. We're not going to comment on an ongoing investigation.
Right. Which leads me to my second thought. Thank you for that reminding me.
Oh, you're welcome.
When the communication director says she was asked to delete her account, which she did, like if there's a question of like whether it was an order or a recommendation, like now we've got the communication director telling a different story.
Right.
And so like, this is one of the things that's so important when you're doing kind of crisis management.
Yeah. Keep your facts straight.
Keep your facts straight and keep everyone on the same page, right? Because like, it's one of those things where like you're playing a game of telephone and somebody doesn't know what you know, or it gets communicated in different ways, or like, like all of these different things, especially to the person who is doing the external communication, they need to know so much, and they need to have a consistent story that is backed up by the facts, right? Like, so, I think there's an opportunity here to do a little bit more internal work to make sure that everyone was on the same page about what was happening, about how to communicate about what was happening. So like, it's one of those things where I read that and I immediately went like, oh, well, that's not the ball game, but like, that really helps the teacher here.
Yes, exactly. Here's how all this sort of ended up in the district before we hit the gavel side of this. So a few weeks later, the superintendent informed Durstein that she was suspended without pay. The suspension letter specifically mentioned Durstein's position and her tweets.
Which, obviously, right?
Yes. Like, here, you're being suspended without pay, and here's why.
Right. And the biggest reason that the district gave, like, we already heard from the communications director that, like, we are committed to having a safe and inclusive environment, right? And so your tweets that were disparaging towards these groups, that makes that undermines those values, right?
Exactly.
And then I think that the letter also said, like, hey, you teach world history, and we probably don't want someone teaching world history who is going to be biased towards entire cultures.
I mean, I think that's a fair statement for a district to make.
Yeah. We'll dig into it in the gavel side. But
yeah. Or at least somebody who is so publicly biased.
Right.
Like, we all have biases, and, hopefully we work to address them and, all of that stuff. But like, we all have them. But again, like, this was really public. Anyway, so she gets suspended. And then at a March school board meeting, the board held a termination hearing and voted to fire her. So she files a grievance with the Public Employee Grievance Board in West Virginia, alleging that she was unlawfully terminated for exercising her First Amendment rights. And then we fast forward to September 2017, and her grievance was denied. Okay, so the Public Employee Grievance Board basically said no.
Okay, so the district wins round one.
Yes. So the final knockout punch happened in December of 2017, so almost a full year after all of this took off. And that was when the West Virginia Board of Education sent Durstein a letter indicating that it was opening an investigation concerning possible revocation or suspension of her teaching certificates. So not only had she been fired, they were basically going to say, we're going to look into whether or not you should even be able to teach here anymore.
In the state.
In the state.
Yeah.
Exactly.
Wow.
So what does Durstein do? So apparently she moved across the river from Huntington into Ironton, Ohio. It's about 30 minutes away. Okay. She got an Ohio teaching license and she started substitute teaching. Okay. She was hired on a 1-year contract, eventually hired on a 1-year contract for the 2021-2022 school year at a school in Ohio. But in October of 2021, that district's superintendent was informed about those tweets and recommended that the board not renew her contract.
Oh, so it followed her.
It followed her.
Well, she didn't go very far away, it sounds like.
30 minutes, but she went into another state where she wasn't going to have to deal with the West Virginia licensing stuff.
Which is interesting because I'm pretty sure if you go to another state, you have to disclose if you've had other licenses. And you have to disclose if there's been any like investigation or action taken against your license. So like,
is that a universal thing? I don't know. Is that a universal thing? Like,
it's a pretty standard. I don't know, but like, I'm pretty sure that was the rule in Ohio, but I don't know. But maybe because it was an investigation, there hadn't been a decision yet. I don't know. But typically there is reciprocity where you have to disclose that stuff.
Yeah. And remember, we're talking about, the span of a good 3 years between when she was told.
Sure. So maybe the investigation kind of
fizzled,
finished up and there was no discipline or. Okay.
Yeah. So anyway, she was hired on this 1-year contract. The district was informed about the tweets and they decided not to renew her contract. Okay. The board initially, this Ohio school board, initially goes against the superintendent's recommendation and renewed the contract. But then the community got a hold of all this information, and pressure that the community put on the board eventually convinced them to vote against renewing her contract.
Okay. So they've reversed course.
Yeah. So once the community started speaking up, they changed their mind. And on top of all of that, the Ohio Department of Education notified Durstein that it was also investigating the situation and placed her application to renew her teaching license on hold pending that investigation. So,
oh, wow. So like it's a 1-2 punch.
She got
over 2 rounds.
Yeah, she got it in West Virginia and then she decided to move to another state. It followed her and it got her there too.
Right. Yeah. So like these, I mean, there's some very serious repercussions here, right? For her social media activity.
I would say so.
For sure. And I think also like, we'll talk about it when we get to the gavel side, but at some point in this time period, she also reapplies to the high school that she had taught at for 18 years that she ended up getting fired from. And they say, we're not interested this time. So like, it sounds like she was struggling to find a permanent position.
Right. So, yeah. So this, whatever she had 16, 17 years of experience came to a crushing end. Pretty abruptly. And even moving to another state years after the initial incident.
Just goes to prove what we said about social media and the internet.
Yeah.
It's always there.
Yeah. Okay. So what happened in the court? So she obviously she wasn't happy about this and she decided to get a lawyer.
Yes. Yeah. Not happy about this whole situation. So after all of this goes down, she files a lawsuit against the superintendent and the school district of the original board. She actually doesn't, or at least not in this case, bring anything against the second school board. But she files this lawsuit in federal court in West Virginia, alleging that her First Amendment rights to freedom of speech were violated when her employment was terminated and the board declined to hire her over her social media posts.
Okay.
She also alleged that the assistant superintendent violated her First Amendment rights when he told her to delete her Twitter account and forbid her from speaking to the press.
Okay.
Yeah. So the case goes through discovery and we get to the motions for summary judgment. So both parties file cross motions for summary judgment.
Which basically, as a reminder, is basically the people saying, I think I win. I win. The facts are on my side. The law is on my side. So I'd really like you to toss this thing out. And the other side was saying the exact same thing.
Right. Yeah. So it's basically like hey, we don't need to go to trial. There's no questions of material fact. I win as a matter of law. Decide for me.
Yes.
And they both said that exact same thing,
Okay.
which is actually kind of nice because then the judge is like, okay, well, I guess we don't need to go to a trial. I'll just decide these motions.
Yeah.
And so in deciding the cross motions for summary judgment, kind of the big issue, or one of the big issues, is whether or not there are material facts at issue. So if there's questions about what happened and those could shape the outcome, then we can't give summary judgment because then we have to go to a jury or to a trier of fact to decide what actually happened. And the other part of that is we have to assume that the facts are most favorable, or we have to interpret the facts in the way that's most favorable to the non-moving party. So basically, like, if you're not the one who moved for summary judgment, then we don't want to give it to you if there's a chance that you could win if we went to trial.
Yeah. So let's say in this case, Mary files this motion for summary judgment. We've got to look at the facts in a way that is going to be most favorable to the school district.
Right. And then vice versa for the school
versa.
district's motion.
Yes, exactly.
Yep.
Yep.
So starting with the school boards, or the claims against the school board. So Durstein claimed that the school board retaliated against her for her First Amendment speech. Basically like, hey, this was my public speech, wasn't part of my job. You weren't allowed to fire me in retaliation for the thing that I said. And this is kind of a really complicated area of law.
Yeah.
Because it balances some really important interests, right? Like individuals have a strong entitlement or a right to freedom of speech. And
at the same time, as an employee and a state actor, right, there are responsibilities there as well.
Right. Yeah. So as an employee, you obviously, have to, I guess, be cognizant of how your actions affect your employer.
Sure.
Right. And then the employer, in this case, the government, the school district, has an interest in its operations, in fulfilling its public mission, in harmony and discipline and all of those other things that like we want to make sure that those government services happen efficiently and that they're able to do their jobs. So we've got these like two very strong interests that are potentially in conflict here, right?
Yes.
And so
how do we reconcile those potential conflicts, Chris?
I thought you would never ask. So this is where we talked about this a little bit in the Kennedy versus Bremerton case.
Yes.
The Connick, Pickering, Garcetti test.
Yes.
So those are all different Supreme Court cases, Connick, Pickering, and Garcetti, that kind of all together give us the test that we use to adjudicate public employee free speech claims.
Yep.
So there are kind of three questions that we have to answer as we think about, well, in this case, there's four, but there's three questions that we typically have to ask to decide whether or not the speech is protected or not.
Okay.
And if the speech is protected, that means that the school violated the First Amendment by disciplining the teacher for this speech.
Yes.
So the first question we ask is, was the speech pursuant to the public employees' official duties?
Okay. So the answer there was no.
The answer there is a big no, right? Like this is clearly not something that she is paid to do.
No.
And this was the big issue in Kennedy, if you remember that, right? Like, was that private personal prayer while he was on the clock? Was it part of his duties? And the court in that case said no.
Yeah, but I mean, there was at least in that case, there was a lot of there were a number of folks who thought it was. Right?
Yeah, the context was much closer, right?
Yeah, it was
this one is
different.
A pretty obvious no.
Right. Yeah, she was just making comments on Twitter posts. She wasn't doing it during school. Like it wasn't part of her class. There was nothing like that. So yes, so I totally get that one. What's the next question?
So the second question asks whether or not the employee is speaking as a citizen on a matter of public concern. And so there's kind of a spectrum here between like matters of public concern, which are the things that like the community cares about. So politics, social issues, whatever it might be. Compare that to things that are purely of private concern. And these are typically like employment matters or things the public doesn't care about that really only matter to the public employee. And so within that spectrum, if the speech is purely private, it's not protected, or purely on a private matter, it's not protected. But if it's on a matter of public concern, then it could be protected. And we move on to the last question. So here, like the school district doesn't really contest that this speech was on a matter of public concern, right? Like it's on politics.
These were big topics at the time.
Right. Yeah. This is a lot of it's happening during the 2016 election. Yeah. Like these issues were coming through. Now, like, there's a difference between like talking about the issues and maybe how she went about it, which like maybe could move this.
Right. But I think at the end of the day, you could look at these topics as she was commenting on what could be considered matters of public concern, right?
Right. And that's why I think the school board decided not to touch that. And also they had a stronger argument for the third question.
Okay. So basically the result of the answer to the second question was, yeah, it's probably a matter of public concern. Let's not fight that.
Let's not dwell on that.
Okay.
So the third question then asks, if it is speech on a matter of public concern, we have to ask whether or not the employee's interest in their First Amendment expression outweighs the board's interest in the efficient operation of the workplace.
Oh, so that's the kicker there, right?
Right.
Like that's the, in light of being able to sort of set the first two questions aside, this third question, it's basically saying who's
got the stronger interest?
Yeah, I was going to say who's more important, but that's not that's not
right.
the right way to phrase it.
Whose interests are more important?
Yeah, basically like, the teacher has a right to free speech. The school has an obligation to be able to run efficiently and pursue a particular mission and whatever. And if those two things are at odds, who's got the stronger interest? Who's going to win?
Right.
Right?
Exactly. Yeah. And so this is the Pickering balancing test. I think like it's really important to think through just all of the different values and interests at stake here.
Oh, yeah, totally.
Right. Because like on the free speech side, this is quintessential free speech,
right.
Assuming we characterize her things as like commenting on matters of public concern, putting aside some of the more inappropriate comments like that's pure political speech, which has really strong protections. And it's in a very public forum, Twitter, right? Like this isn't something that she said in the backyard.
Right.
But that also means it's super duper public, right? Which goes to kind of the board's interest here.
Yeah.
So like, there's a lot to unpack here. And to help us unpack that, the court gives us some things to think about when thinking about balancing these interests.
Yeah.
So there's a bunch of factors that the court gives us to think through whose interests here win. So, Jamie, I'm going to read these to you, and I want you to think about like which one of these factors seem to apply to this case, and how do you think the court adjudicated them? So,
okay.
You ready?
Yep.
All right, so things that we think about. Whether a public employee's speech, 1, impaired the maintenance of discipline by supervisors, 2, impaired harmony among coworkers, 3, damaged close personal relationships, 4, impeded the performance of the public employee's duties, 5, interfered with the operations of the institution, 6, undermined the mission of the institution, 7, was communicated to the public or to coworkers in private, 8, conflicted with the responsibilities of the employee within the institution, and 9, abused the authority and public accountability that the employee's role entailed.
Oh, boy.
Yeah, no, you read through those and you're like,
wow. Yeah.
Durstein might be in trouble here.
Yeah, no, I mean, with the exception of maybe one of those things, right? Like all of those considerations are just on the surface looking pretty solidly in favor of the school at this point.
Right. Yeah. And so, the board is arguing here that all of these factors weigh heavily in their favor.
Yeah.
Durstein, on the other hand, says that like her speech didn't cause a disruption, right? Like, which maybe or maybe not, but like that kind of misses the mark because disruption really only matters for student speech.
Yeah,
right?
Student speech.
But Durstein goes a step further and argues that the disruption wasn't caused by her speech, but was instead caused by, and this is language from the brief that Durstein's attorneys filed in front of the court. It was caused by, quote, self-righteous republishers who retweeted and spread her tweets.
Oh, really? So she's just blaming the other tweeters.
Yeah, right. Yeah. So like not a great look, but she's got a point, right? Like, well, maybe she has a point.
Well, I mean, the point she's trying to make is like none of this would have been a problem had all of these Twitter users.
Mm-hmm. And I would have gotten away with it.
I would have gotten away with it.
If it hadn't been for you meddling kids.
Okay, Okay, that was a Scooby-Doo reference, kids. Scooby-Doo was a cartoon back in... Anyway. Yeah.
So, you know, I think the elements that really jumped out to me, like conflicting with her responsibilities, right? Like that's the big one.
Well, yeah,
that
she's a world history teacher. She teaches about different cultures. She's supposed to teach about their contributions, their, you know, different ways that we value these cultures and the value that these cultures bring to the world and blah, blah, blah.
Exactly.
And she's clearly
biased,
or she clearly does not feel that some cultures have the same value or worth as others.
Right. Exactly. And the court,
cultures, races, whatever.
Right. And the court hits that exactly like you said. So in the language of the court, they say it is important that a teacher responsible for instructing students about other religions not be seen disparaging those religions publicly.
Yeah.
Thus, the content of her tweets and her expressing prejudice is contradictory to her specific responsibilities as a teacher.
You know, so it's very interesting, though, like what would have happened if she was a math teacher?
Right. Well, and I think the district still gets to the same point, right? I think they still could have taken the same actions.
I think so, too.
Because, and I think like just that is just so like, it's so obvious, right? That like, hey, that directly conflicts with what we pay you to do. But like the other things here would apply to any teacher. So impairing maintenance of discipline, like that's a huge one because the school board has a bunch of anti-harassment policies, right? Yeah. There's anti-bullying, anti-harassment. Yeah. There's policies about making this a safe and inclusive environment.
Well, I think that's the piece that goes to it doesn't matter what subject you teach, right?
Exactly.
Like most schools have these sort of missions or these initiatives that encompass creating a safe environment, being inclusive, respecting everybody's differences and blah, blah, blah. Mm-hmm. And that is going to apply to any teacher, no matter what you teach.
Right. Yeah. So the board policy, they had a policy that said it is the responsibility of all students and employees to promote and maintain an environment free of all types of religious and ethnic harassment. Mm-hmm. And, you know, the record shows that there's a lot of situations where after this was all going down, like teachers were coming forward saying like, hey, I'm uncomfortable with all of this.
Right.
Like I'm uncomfortable having her as a colleague. I'm uncomfortable interacting with her because I identify as Muslim. There were a ton of students who were coming forward saying like, I don't want to be in her class.
So then all of that satisfies those other points that you mentioned about, you know, impairing the harmony among coworkers, damaging personal relationships, you know, all of that stuff. Right.
Yeah. And then the last one is that kind of jumped out at me is like undermining the mission of the institution. So not only does the speech kind of contradict the egalitarian goals of the district, making sure that, you know, it's a safe and inclusive environment free from harassment and discrimination. But, you know, there was a lot of evidence here about like the community response and the disruption. Like if the school doesn't react to this, like that could really harm their standing in the community. It could harm their kind of like their reputation, like how they're viewed, all of those different things. And then there's also like the disruption, like, you know, Jamie, you and I have talked about this a lot, like the man hours that go into responding and dealing with stuff like this, whether that's counseling students, addressing parental phone calls, concerns from the community, all of those different things. So like all of this really kind of undermines the mission of the institution.
Totally.
And this was one of the most public kinds of speech we have today, where you just put a tweet out there and it can take on a life of its own. So this is very much communicated to the public rather than in a private setting.
Exactly.
So like put all of those together. And I think that the factors, and the court agreed that the factors weigh heavily in the school's favor.
Okay.
But, you know, to go back to Durstein's argument that the original tweeting didn't cause the disruption, the retweeting did. Mm-hmm. The court doesn't buy that. That argument, that dog don't hunt, because the court says the account was public. It was in her real name. And to find it, all you had to do was search for her name on Twitter and it would pop up. And retweeting is just a thing that happens on that site. So you just kind of have to accept the life that your tweets take on once you put them on the platform.
Yeah, it's almost like she was trying to make the argument that, you know, my speech isn't the problem. Your reaction to my speech is the problem.
That's actually a big argument that she makes. So she argues that essentially what the board did is it engaged in a heckler's veto. A heckler's veto applies when the threat the speech assertedly posed to the employer's interest was not internal disruption by the speech itself, but external disruption by third persons reacting to the speech. So Jamie, like, that's exactly what she's arguing here. She's saying, hey, look, the things that I said didn't cause the disruption. It's all of the reactions that people got. And, you know, we don't want to punish people's speech because it incites negative reactions from a crowd, because then like the crowd is going to silence speech. And we don't like that because we like lots of speech.
Right.
So like, you know, it's essentially people don't like what I said. They caused the disruption because they didn't like it. It's not my fault.
Like we said, it's not about the disruption.
Right. And
it's
the court
about
says,
the speech.
Exactly. And the court says, nope, exactly that. The content of the speech here was very much the issue, because the court says teachers are in a position of public trust. They have significant contact with the public. That, coupled with the fact that she was supposed to teach students about different religions and she taught a diverse student body, like clearly the content of the speech mattered because of its potential to erode public trust in the school and disrupt the school's activities and mission. So here, like, it was the speech itself that was the problem. And so for all of those reasons, the school district gets summary judgment on the First Amendment retaliation claim.
Okay. So then the other one was about the decision not to rehire, right?
Rehire, and that's the exact same analysis where the court basically comes back and says, like, they were justified in firing you. They're justified in not rehiring
exactly.
you too.
Yeah, that makes perfect sense.
Yeah. And so the last thing is the claims against the superintendent. So the claims against the superintendent were not for the firing and the not rehiring, but were for making her delete the account and also forbidding her from talking to the media.
Oh, right. Yes. Yeah.
And Jamie, this all hinges on, can you guess?
I'm going to guess it's qualified immunity again.
It's qualified immunity.
Oh, we love qualified immunity.
We do. We talk about qualified immunity a lot. So to remind everyone, a government official who performs an act clearly established to be beyond the scope of his discretionary authority is not entitled to qualified immunity. You get qualified immunity when essentially the...
So if the employee was working within the scope of his responsibilities, okay, then you can potentially have qualified immunity.
But then there's a two-step inquiry after that,
right,
where we have to look at whether or not the official's conduct violated a clearly established constitution. Exactly. Yeah. That's the crux of the matter, is whether or not a reasonable official in their circumstance would know that this violates the Constitution. And, you know, the goal of qualified immunity is to give government officials breathing room to make reasonable, even if they're mistaken, judgments about open legal questions. So like, these people aren't attorneys, they're not lawyers, they're not judges. They need to have some ability to kind of like work within the gray areas to get their job done.
Right.
So, you know, for the purposes of qualified immunity, because remember, this is a motion for summary judgment, so we just assume that the assistant superintendent ordered Durstein to shut down her Twitter account and also forbid her from speaking to the media.
Yeah. And because so basically what they're asking at this point is, assuming he did that,
would that be a violation?
Would that be a constitutional violation?
Right.
And I'm guessing that they said no.
Well, you would think that. So for the shutting down the Twitter account, they say, no, that's not a constitutional violation.
Yeah, that's what
Yeah. So for the shutting down the Twitter account, the court looks at the superintendent's broad authority to investigate and discipline employees, as well as kind of pursue the educational goals of the district. And looking at all of that, the court says that, like, you know, it was perfectly reasonable for the superintendent to investigate and then try to kind of mitigate the harm of what was going on.
Yeah. So basically they're saying, look, I investigated, I saw all this stuff that I found. It wasn't necessarily about them finding it offensive. It was more about, like, I am looking at things that could be considered discriminatory. Right.
And I need
to shut that down.
Exactly. And so shutting down the entire account was a reasonable way to handle that.
Yes.
And for me, like, I think that's so dependent on the context, right?
Of
like,
course.
If this had been a different context, like,
this one's not black and white.
Right.
No.
Yeah. I'm very suspect of, like, public officials telling people not to have social media or to shut down accounts.
Totally.
Or even when public officials, like, ask you for your Twitter handle so they can, like, do a deep dive. And, like, all of that stuff just feels icky. That's a very legal turn of phrase. So, you know, I think the context here really matters, but the court kind of says, like, no, this was within their authority and it's not a constitutional violation for all of the reasons that we already talked about. Importantly, you know, this speech had already happened, right? Like, we're kind of censoring speech that had already taken place and punishing her for it. But that's not the case with the order not to speak to the press. So assuming that the assistant superintendent told Durstein not to speak to the press, that's different.
Yeah.
Because that isn't punishing speech that's already happened. That's silencing speech that is yet to happen.
Yeah.
And so in the law, we call that a prior restraint, where essentially you are stopping someone from speaking before they speak. And
Yes.
the law is very, very suspect
Yeah.
of prior restraints
Yes.
because you don't know what they're going to say. It's much better to punish someone after they say something rather than to stop them from speaking in the first place.
That's the movie Minority Report.
Hey, yeah,
Sort of.
that's a good one.
Anyway.
So basically we have to apply the Pickering balancing test, our 3 questions, to decide whether or not this speech was protected.
Yeah.
And, pursuant to official duties, no, it's not part of our job to speak to the press. Is it not a matter of public concern?
Yep.
Yeah.
Yep.
This thing's blown up.
Mhm.
The public is very interested in what's going on with Durstein and the district. And then this is the one that I think is really interesting. The balancing test between the employee's interest and the public's interests. I think here, and the court agrees, like that weighs in favor of the employee.
Yes. Yes.
Because if you take away her chance to talk to the press, you're basically taking away her chance to tell her side of the story,
Exactly.
to defend herself, to apologize if that's what she wants to do. Like, you don't know what she's going to say. So at that point, like that becomes really problematic. And the school doesn't really have an interest in that other than maybe like trying to avoid like continuing controversy, but like you don't know if she was going to continue or make things more controversial through her speech. So like it was, here it's not only does the district not have a very strong interest, but the employee has a really strong interest. And the court goes on to say, the public also has a pretty strong interest in hearing what she has to say.
Yeah.
Because if this controversy is about her and the district, like the public has an interest in hearing both sides of the story.
Now, and it kind of goes back to what I said earlier when I was critical of the district going out there and telling their side of the story. Okay. And when I said that usually in a lot of these situations, you have the school district, keeping things pretty mum. Right? Like we're not going to comment on an ongoing investigation. This is a personnel matter, blah, blah, blah. In these situations, you often don't hear from the district and you do hear from the accusing party, right? More times than not, I would say, in these sort of, district versus somebody else controversies. And so, like you could look at this and say exactly that. Like, you know what, we're going to tell our side of the story, but we're not going to let you tell your side of the story. And that is like, there's so much about this case that I'm like, man, that teacher, you don't have a leg to stand on. You're not even anywhere close to winning anything but this piece.
Right. And that's what the court kind of says is like, hey, assistant superintendent, you don't get qualified immunity for this because it could be a constitutional violation, right? Like,
exactly.
So this is the only piece of the complaint that survives. And so this is the only thing left after the court's decision.
Okay.
And that's actually like the last I was able to find about this case. So there's no subsequent decision about whether or not the assistant superintendent actually required her to shut down her social media and whether or not that was, if a court actually found that to be a constitutional violation. I assume that means that they settled or the teacher just kind of dismissed the complaint, dismissed the case.
Yeah. Yeah.
But I have no idea.
It's always a bummer when we get to this point after, going into so much detail about a case and the facts and looking everything up. And then you just want to know, how did this all just like end up? And nothing.
Well, and a lot of these just kind of fizzle out anyway, right? Like there's this massive fight. And then it's just kind of like, and then it was over.
But you're not here, folks, for the punchline, right?
Hopefully.
Because they're very bad. Our punchlines are terrible. No, but the whole idea behind this show is that we can wrestle with these ideas and we talk about how the court wrestled with them so that, all of you teachers who are listening, can listen to this episode, for example, and know, these are the things that we need to consider before retweeting this or that or whatever.
It's not the journey, or it's not the destination. It's the journey.
The journey.
Exactly.
Yeah.
So just kind of like wrap up. I think like social media use is such a tough issue because like it is one of those things where I think a lot of teachers are really worried about it going viral or about people kind of picking it up and what that can mean for their relationship with their school, their community, their students. And I think that like, you know, the law is one thing, but like community reactions is a totally different thing. Where like, yes, your speech might be protected, but like, how do we address the potential non-legal consequences of it? Because I've talked about it on the show, like I'm a very strong proponent of free speech. And, you know, because of that, I also am a strong proponent of protecting speech I don't like. I just think that's kind of like the rules of the game. So for me, I always like hesitate about recommendations that would have teachers not engage on social media, but also recognizing just kind of the practical implications.
But I think that's it, right? Like I think that's because I agree with you. Like I'm all about free speech and all of that stuff, but you know, I'm also very dedicated to ensuring that schools can fulfill their pedagogical objectives and that they need to have a certain degree of flexibility in order to carry out that mission, right? Effectively.
Right.
And, you know, but those two things can be at odds with one another. But I think that, you know, the whole reason why we do this show is to build a more legally literate educator. Right.
So that they know where those lines are.
Exactly. And
legally, at least, but also morally and ethically.
Exactly. So that they don't need to, I mean, ideally, you don't need to be told to not do social media.
Because you're doing it right.
Because you're doing it right, because you know where the goalposts are, right?
Mm-hmm. Right. Yeah. Because the things that get teachers into trouble on social media are things like what happened with Durstein, right? Like taking extreme political views or engaging in racist, xenophobic language, right? That demeans other groups.
Right.
And, you know, the other kind of big category of things that gets teachers into trouble is like talking about their students or their schools, or like, you know, we've seen a ton of cases about like teachers bad mouthing their students on social media. And that's kind of like the thing. Like if you don't do kind of those two things, if you don't like engage in this incredibly controversial speech, and if you don't talk about your job in ways that would undermine people's beliefs in your ability to do your job, like you're probably going to be okay.
Right.
You know, if you do want to engage in controversial speech or, you know, engage in some like, I don't know, interesting artistic endeavors, right? Like then maybe don't use your real name, right? Like don't make it so easy for your students to find you.
Yes, exactly.
Right? So like the more controversial, and this is advice that I've heard, and you know, I think ethically it holds up. Like the more controversial your public speech, the more distance you should put between that speech and your employer, right?
That's a good rule or
and I
guideline.
think like that's a
good suggestion.
It's a more nuanced way of approaching this whole situation, right?
Yeah, exactly. Man, this was a good one.
It's a timely case.
I'm
glad we did this one.
It's a timely case. I'm sure we're going to have lots of this stuff in this Groundhog Day election coming up. And shout out to Janet Decker for recommending this case for us. Oh, thanks, Janet.
Yeah, that's where this came from.
Nice. No, this
friend
is a
of the
great
show,
one.
Janet Decker.
Yeah. This is a great one. This is one I'm going to tell my teacher prep colleagues about, because unfortunately, as we know too well, there is very little legal literacy happening in teacher prep programs in this country. And so it's, you know, the number of people I've spoken to that have said, man, this course would have been so helpful when I was becoming a teacher.
Oh yeah. We're filling a need.
Yes, exactly. So, okay. Well, that's good for this one. Episode 26 is in the bag. Let's sign off. What's our homework, Chris?
Your homework, same as it ever is, speaking of Groundhog Day, is to like, rate, and review Chalk and Gavel wherever you get your podcasts. We'd love to hear from you and continue the conversation. If you have ideas for cases for us to cover, please share those with us. If there are topics you want to address or situations that you think would be good for us to explore, please let us know. You can find our teaching guide at chalkandgavel.com. You can also find us on Patreon. We would love it if you would support us. $2 a month would go a long way to helping us continue delivering this show. We're working on some fun subscriber-only content that will hopefully go live here in the next couple months. So keep an ear out for that. And I think that does it for your homework.
All right. Sounds good, folks. Then we'll see you on our next episode where we talk more about connecting the courtroom to the classroom.